We're going to begin our program again. And now we are going to go into pre-trial and post-trial motions in state and federal court. We have a distinguished panel here today, moderated by Alan Ruley of Bell Davis Pitts Winston-Salem office. Alan is he's a distinguished litigator. He has an undergrad degree from Duke University and a law degree from Stanford. He's a seasoned civil trial attorney who has dedicated his practice to state and federal business litigation disputes, intellectual property, insurance, banking, and employment. Alan will introduce the other members of the panel. So I'll turn it over to Alan at this time.
Thank you, Marte. We do have a terrific panel today, and I'll encourage you now and probably again to ask questions. We have two judges here, a state court judge and a federal court judge. Our state court judge is Todd Burke. He's the senior resident Superior Court judge in Forsyth County. He's been a Superior Court judge since December of 1994, so almost 23 years. He's a graduate of East Forsyth High School, Morehouse College, and NC Central. He was a prosecutor in Kinston and Winston-Salem for a while after law school, and then he was in private practice in Winston-Salem, and then he was appointed to the bench by Governor Hunt in 1994. Our federal judge is Tom Schroeder. He's with the U.S. District Court for the Middle District of North Carolina, and he's been there since January of 2008, almost 10 years. He's based in Winston-Salem. Before he became a federal judge, he was with Womble Carlisle in Winston-Salem for over 20 years, doing a variety of business litigation and product liability work on a national basis. He went to Kansas undergrad, Notre Dame Law School, and clerked on the D.C. Circuit before he went to Womble Carlisle. So between them, we have two judges here with over 30 years experience as judges and 60 years experience as lawyers. So I encourage you to take the opportunity to ask questions of them as we go along today, because you rarely get an opportunity like this. And then we have two equally distinguished young lawyers with us. Kelly Dagger is with Ellison Winters in Raleigh. She does both civil and criminal work. She went to Chapel Hill undergrad and the University of California at Berkeley for law school. And she is also a competitive runner and has done marathons and half marathons, unlike me and probably most of us. Kevin Pratt is our other young lawyer. He's with Lincoln Durr in Charlotte. He does a lot of professional liability defense, particularly med-mal, as well as commercial litigation. He has a bachelor's from Elon, where he was a four-year letterman on the baseball team and captain of the baseball team, a master's degree from the College of Charleston, and a law degree from Charleston Law School. So to begin with, maybe Kelly and Kevin, could you give us an overview of what we'll be talking about today?
Yeah, and I'm the one who gets to test the microphone here. Can you hear me? Excuse me, thanks for being here today. Our panel is going to cover, as advertised, pre- and post-trial motions. On the pre-trial motions front, we've already heard about a number of different types of motions, Rule 12 motions, party motions, things that might be filed before a trial. But that's not really what we mean, or at least what I mean when I'm talking about a pre-trial motion. So what I would include in that category is, at the point when I think my case is going to trial, what motions might I need to file before the trial? Most frequently, for me anyway, that's going to be evidentiary motions in limine. It might be something specific to an expert, a Daubert motion, or sometimes there are other, what I would call procedural motions, such as a motion to sequester witnesses or something to modify the typical courtroom procedure that I might file before trial. And so, again, I wouldn't include in that everything that you might file before a trial, but the ones that are specific to the conduct of the trial. And then we're also going to cover what happens post-trial in terms of motion practice, which might be a motion for judgment as a matter of law after an adverse jury verdict, for example, or a motion for a new trial. And I'll let Kevin fill in the things that I'm missing specific to, I think he said, his focus is in state court.
That's okay. So, as Kelly mentioned, I think our practices, one of the most meaningful distinctions is I'm largely in state court, some in business court, but mostly in superior court. So, when we were talking about the scope and breadth of what the pretrial motion practice and post-trial motion practice would be, she offered a little bit more refreshing perspective, because in state court, I felt like any kind of motion that we were filing before a case went to trial is something that I would necessarily characterize as something that was pre-trial. But for the purposes of our conversation today with these judges, I think we're going to try and stay within the framework of the evidentiary stuff, and assuming that you've already lost a dispositive motion such as a summary judgment, because we know that we're going to hear about summary judgment and how to do that at 12:45. So we're really going to focus pre-trial from having already lost a dispositive motion and what that looks like based on our experiences from the federal and state court practices. And then post-trial, one of our big themes, I think, that recurred in some of our materials is having an eye towards issue preservation and what appellate court issues need to be thought about both pre-trial and post-trial.
Thank you. So why don't we start with pre-trial motions, and probably a good place to start is motions in limine. You're going to go to trial. You need to think about what evidence is likely to come in, what evidence you want to exclude. You can have defensive reasons for filing a motion in limine, offensive reasons. Kevin and Kelly, can you give us some of the considerations you go through when you decide whether to file a motion in limine, and if so, what to file?
I'll go first only because the mic's closest. I think one of the big things that...
How big is it? It was right here. No, not
Sure. All right. One of the big things that we consider when deciding whether to move to exclude evidence in limine is what type of witness this person is going to be, because I think that one of the strategic things that we like to think of is, even if perhaps there is a justifiable and rule-based reason for that evidence to be excluded, is the potential value of cross-examining that witness and undermining the weight and credibility of the evidence as important, or perhaps equally important, as the possibility of getting the evidence excluded. And so having a view as to how important that evidence would be to the ultimate potential for a bad outcome against your client. I think that's something that we always like to view trial as your chance to tell your story, and if a big part of your story is the lack of weight or credibility of any type of evidence that you're trying to exclude, then you might forecast your strategy or in a way that might kind of allow them to prepare for that type of approach.
Does this work? Should we turn this on? Oh, okay. We can share the microphone. Okay.
So Kevin nicely illustrated the first rule of trial practice, which is to do whatever the judge says. So if the judges ask for the microphone, I'm going to give it to them. One of the things, just building on what Kevin said, that I think about when I'm trying to decide whether to file a motion in limine is how complicated is the evidence or argument. If I want to exclude some evidence or argument, is it complicated enough, either factually, or is the legal background, the basis on which I want to exclude it, complicated enough that I think it would be useful for the court to have written materials in advance describing what the evidence is going to be, what I think it's going to be, and why it isn't admissible. Of course, you're going to be able to object at trial if the other party's counsel asks a question and you think, I don't like that, I don't think the answer to that is going to be admissible evidence, then you're going to object and preserve that at the time. But you want to think in advance, is this the kind of issue on which I need to submit briefing? Maybe there's Fourth Circuit case law that's controlling. maybe the facts are complex and you want to at least take the opportunity to provide that information to the court in advance and inform the court's ruling to that effect. Another thing that I try to think about when filing a motion in limine is, what is the other party going to take from that? What am I saying to the opposing counsel about my trial strategy or what I think about her trial strategy by filing that motion? I'm giving the other party some advance notice of what I think, and I might want to do that. There might be a reason that I want the other party to think I'm focused on this issue. There might be a reason that I don't want that. And so I would also take that into account. Another thing that I might think about, it's possible that there's some issue on which I think I think the evidence is so gravely prejudicial if it comes in that I feel like it is appropriate, if I can get it, for a pretrial ruling, so that I don't take any risk that that issue will come up at trial. The court has the opportunity, at least if I prevail, to instruct the parties in advance that evidence is not going to be admissible. And one of the reasons that that is important in trial practice is because opening statements are going to come before any evidence has actually been admitted, before any of the lawyers have asked any questions of any of the witnesses or introduced any documents. The jury's going to hear opening statements, typically. It's going to hear opening statements from the lawyers, and the lawyers are going to forecast what the evidence is going to be. And if there's something that I think can't or shouldn't come into evidence, I want to ask the court ahead of time, don't let the other party's counsel forecast that that's going to come into evidence. And sometimes the court will say, I'm going to reserve ruling on that, but Ms. Dagger, don't you mention that in your opening statement. And sometimes not, but that's a time, and really the only time, when you've got the chance to affect the content of the opening statement by asking the court to rule on something before trial.
So that's kind of a good segue into a question for our judges. Sometimes a judge will hear and decide a motion in limine. Sometimes a judge will hear and say, well, I'm going to defer ruling until later. And sometimes I've had judges say, I don't want to hear them at all. Let's just see what comes up at trial. We may not even need to face the issue. So I think it'd be helpful to hear from Judge Schroeder and Judge Burke on how you handle motions in limine, and any tips you have for the audience on how you like for lawyers to handle motions in limine.
All right. Well, put yourself in the judge's position, because sometimes, particularly when you're younger and start out, you're thinking, I need to get this motion done, I need to get this filed, and then I have to do this, and I have to prepare my opening statement, and you're not thinking about the position of the decision maker, and that is, did I get this in time to make an informed decision? So if you file your motion in limine as you're walking into the courtroom, or hand it up to the judge, you're going to get a certain amount of reflection on your decision. If you file it a week in advance and the judge has a chance to look at it, and it's a complicated issue, then the judge has more time to pay attention to it. So the first thing I would say is think about your issue. Is it one that needs reflection, or is it pretty clear cut? And make sure you file whatever you file in time, so the other side can respond to it and that the judge can actually reflect on it and have a copy of it. We have a lot of stuff we're doing before trial, just as the lawyers do, and timing is important. In the Middle District, we have local rules that cover your obligations on when you file your jury instructions and your pretrial 26A3 disclosures. I don't believe we have a rule on motions in limine per se, so another thing to do is ask during your pretrial conference if there could be a schedule for that, particularly if it's going to be complicated and there will be a number of motions. If it's a motion that's fairly straightforward, well, let me say this as a starting point. For me, I like to decide them all ahead of time if I can. I think the lawyers are entitled to know what the rules are going to be before they go into court. And having tried cases, I never liked to be in the position where I had to kind of just wait and see how things unfolded in the courtroom, because you do a lot of planning before you get there, so I appreciate that. If it's a motion that can be decided ahead of time, I usually will schedule a pretrial conference and we'll talk them through, and then I'll rule from the bench. If I have to write something up, I will, but I'll try to avoid that. If it can't be decided, or if it's going to depend on how the case unfolds, we'll talk about it, and I may do exactly as Alan said. I may say, don't mention, or maybe Kelly mentioned, don't mention it during your opening. I'm going to see how the case kind of unfolds, but I'm inclined to go this way or that way. And I usually try to let the lawyers know which way I'm inclined to go, just so they know. My experience is about 50% of my motions in limine eventually work themselves out, and I don't have to make a ruling. The lawyers eventually realize what's important, what's not, and they decide what they want in evidence, what they need in evidence, and I don't have to rule on it. And if it's a bench trial, I will rarely rule on a motion in limine because it's all coming to me anyway. And if I have a separate hearing on motions in limine, I'm just taking up extra time, and I can do it all in one proceeding because I don't have to worry about keeping something from the jury.
Thank you, Judge. Good morning. Good morning. Can you hear me? May I ask a question, Judge?
Sure.
In federal court, are you assigned to court a case from beginning to end?
Yes, with a caveat. In every district in the Fourth Circuit, except for the Middle District of North Carolina, you're assigned a case, and that's your case through trial. In our district, you're assigned the case up through trial unless it comes up on a trial calendar that's not yours. And then that judge will try it.
And that's a distinction between state court and federal court. Unless you're in business court or it's a 2.1 case, when you come to trial calendars in state court, the judge who is going to preside over the trial may not have heard anything about the case before trial. That's something I kind of like, is catching up with the lawyers. You've put in all this work as far as discovery. So the motions in limine gives me an opportunity to get a clear understanding as to what the case is in an attempt to catch up with you with all the research you've done and what the issues are in your case. So I would say know your judge, know who you're speaking to if you can. If you know any background information on that judge, that will assist you in how you go about those motions in limine. Some of the motions in limine are just boilerplate. You see them constant. But then, as the attorneys have alluded to, some are very important because they may involve prejudicial information pursuant to rules 404, 404B. And you don't want an attorney to say something in an opening statement that may be eliminated with a motion in limine. If you would go back historically, and I imagine some of the older lawyers may know, motion in limine was something was sort of new. Before, judges would just hear cases. There was no such thing as a motion in limine. But I think the motions in limine are important because they do give you an opportunity to enlighten that judge as to what your case is. I prefer, as Judge Schroeder stated, to hear all those motions prior to trial. I want, because as I said, it enlightens me as to what your case concerns and what issues are important to you. But I would say don't get too caught up in the battle versus the war. Sometimes attorneys, as this artful attorney has stated, lawyers will put a motion in limine there to distract you, and you're so focused on it, and you are forgetting what the war is about, what the actual trial is. So pay close attention to that. But generally, motions in limine in state court are an opportunity for you to get familiar with that judge and familiarize that judge with what your case is about, because more times than not, oftentimes than not, that may be the first time this judge has been associated with your case. He hasn't heard any 12B motions, he hasn't heard a summary judgment motion or anything else concerning your case. And a lot of times attorneys know when they have a complex legal issue, and they will join to see if a judge will be willing to meet with them on a Thursday or Friday prior to the trial to give that judge an opportunity to make an informed decision about that motion in limine if it is a complex case or a complex issue. But more times than not, the judge hears those motions in limine when he calls that matter for trial. Generally, if I know matters are for trial, I will hear all those pretrial motions in that trial before I proceed with perhaps a motions calendar involving the other attorney. So the lawyers who know that their matter is going to trial, they can leave and come back maybe at 2 o'clock in the afternoon or when we think we may be through with those motions and proceed with their trial. So, and then that gives me more time, and even over the lunch break, as far as familiarizing myself with the case if I need to.
Yeah, thank you. Judge Burke brings up an important distinction in regular state court. You know, when your case is called for trial, you may very well get a judge that's never had the case before, so the judge knows nothing about it. I've always thought that makes a state court judge's job even more hard than it would otherwise be. But Judge Burke, do you like for lawyers to give you briefs on their motions in limine, given that, you know, it may be Monday morning and you don't have a whole lot of time, you've got a motions calendar and then you're going to pick a jury, but do you find those helpful, or would you rather just hear argument?
Funny story. As you heard from my background, I practiced primarily in the criminal arena before I became a judge. So some judges I like the operation of certain areas of law that I didn't practice in. But the first time I had civil court as a Superior Court judge, I came in on that weekend and I read all those files to get familiar with them. And then I began to call the calendar. Oh, Your Honor, that case has been settled. Your Honor, we're not going to need to hear that motion now. And so, but it was new for me. Just like I have a couple of colleagues, they never practiced criminal law, and they get these motions for appropriate relief, and they say, what is this? And so, as I said, that's another thing, knowing your judge, who your judge is. But in any event, in that you don't know whether the case is going to actually go to trial or the motion is going to be heard as a judge, I really don't think you need to get those briefs to the judge until the matter is going to be heard. Because if judges have had that experience that when they call the calendar, matters are settled, why are you going to read all that information if you're not going to be ruling on it? But once again, know your judge. Some judges are more fastidious and meticulous than others, and perhaps they want to read everything regardless as to whether it's going to be heard or not. But just be aware of that. And proper pre-planning prevents poor performance, so it never does hurt to give the judge anything in advance. And if he chooses to read it, fine. If he chooses not to, at least you have taken care of your due diligence in getting that matter to the court.
Thank you, Judge. Kevin and Kelly, could you talk a little bit about how your trial strategy is affected by a ruling or rulings on motions in limine or decisions to defer ruling?
Sorry.
No, it's fine. I always like to assume that I'm going to lose. I just think it's a safer strategy because.
But as they say, a pessimist is never disappointed.
Exactly. Assume the worst, hope for the best, and you'll never be disappointed. I think from the defense perspective, which is predominantly where my practice focuses, I think you also do your clients a good service because it challenges you to develop alternative strategies for trial and different paths to victory, if you will. I think depending on what ruling is being deferred or what the evidence is, I think it's difficult to perhaps give very specific examples of how you could strategize about alternative theories, but I think that's when you have a situation where a judge is deferred ruling and you know that you're going to be in a situation where the evidence, there's going to be an opportunity for the evidence to come in, it becomes even more important for you to make all of the objections that you need to make at trial and then potentially after a verdict, because that's where the issue preservation issue is going to become important, because absent a ruling, a pretrial ruling on the motion in limine, you're going to be put in the position of preserving all those issues, because perhaps the cumulative prejudice of all these evidentiary rulings may be a meritorious appellate issue that can give you some leverage if you did not win at trial, unfortunately. So I think that's the biggest thing. If you are in a situation where you feel, or the judge indicates that he's going to defer, it should trigger a heightened awareness for objections that you can and probably should make at trial, and then having an alternative path to victory, even assuming all that bad evidence comes in and all the what you feel like are improper rulings are made, you still got a way to get to past the finish line.
So I think sometimes the court's ruling or lack of ruling, rather, on a motion in limine can also force a difficult trial strategy issue. It may be that I've moved in limine to exclude some evidence. Kevin's the opposing counsel, and he wants to put on some evidence that my client is a bad person. And so we go into court, and Judge Schroeder says, well, I got to see how that develops. I got to see how the evidence comes in. And I think, all right, well, great. Now I've got to think about this, and I've got to think, well, so if this issue comes up again, and Kevin asks the question of the witness, so, isn't Ms. Dagger's client here a really, really bad person? How do I want to react to that? Do I want to try to raise that again? Do I want to say at a recess, Judge Schroeder, we've heard the evidence come in now, and I've asked you to take a look at this again. Or maybe the judge has denied the motion in limine, and I've got to make a difficult decision about appellate preservation, because I think, what I would like to do is, I would like to not prejudice the jury. If it's something that I think is sort of bad character evidence, for example, I'd like the jury not to be prejudiced by it. And based on the ruling on the motion in limine, based on how clear it is or how favorable or unfavorable it is, I might want to make a decision not to object during the trial to certain evidence because I don't want to draw further attention to it. And I think that goes back to the point that Judge Burke was making about not losing sight of the overall strategy. So you can get so geeked up, so focused on your motion in limine, so focused on some pretrial evidentiary issue, you still have to be ready to try your case. And you can't be so focused on that issue that you lose sight of your trial strategy. You might need to drop it and say, fine, all right, that evidence is coming in, or it looks to me like the look on the judge's face is, if that comes up again, that's not going to go in my favor. I'm going to drop that. I've got a plan B, I've got a different strategy, and I'm going to be able to account for that. And I think really the only way that you can be prepared for all the outcomes is you've got to look at your case before trial, you've got to look at the evidentiary issues that the other party might raise and your own evidentiary issues. You've got to do that really critically so that you can be prepared to try your case anyway, depending on any ruling. And then once the judge rules, so Judge Schroeder and Judge Burke both told us that they do like to rule before trial if they can, which, thank you. We would all appreciate that, I'm sure. Lawyers appreciate that certainty. But then you need to be prepared to do something with that. So if the judge grants the other party's motion in limine, and you're there in the courtroom and you're getting ready for trial, and it's, you've got all your notes for jury selection, and the judge says, by the way, I'm granting that motion in limine. You've already prepared all your witnesses and you're all ready to go. You need to remember not to try to introduce that evidence if that ruling went against you. So that means you need to think about the work that you've already done, and you need to be flexible and be able to react on the fly so that you can comply with the court's rulings.
I would add, make sure you understand the ruling of the court. So if you have any question, and sometimes these are nuanced questions, like how much of this comes in, or the judge may split the baby and say, I'll let you ask this, but you can't go any further than that. Make sure it's clear. And if it's not clear to you, ask, because you don't want to get across that fine line when you're in court and have the judge call you down in front of the jury. The other thing to do is, and by the way, we're trying to get it right, so if you have questions, maybe we haven't been clear, so please ask and tell us. You need some clarification. The other thing is, make sure your witnesses understand, because I've had occasions where I've ruled and it looks like maybe the witness wasn't counseled as to what the limitations of the testimony would be, and they were loaded to bear for bear because they really had this issue that motivated them to testify, and now the judge says, well, that's not coming into evidence. So just make sure they understand it can't come in and what the consequences are. So counsel your witnesses so they know the extent of the ruling.
So, thank you. Another important issue on motions in limine is making sure you preserve the issue for appeal. And I know the rules on that maybe aren't what they appear to be sometimes. Could you talk about that a little bit?
It's your turn.
So suppose Judge Burke, suppose you've granted a motion in limine, you're excluding evidence. How would a litigant make sure that they can preserve that issue for appeal? What are they can't present it in the presence of the jury, what do they do?
Right. Judge Schroeder made an interesting point with a bench trial. You can just let it all hang out, and that you're relying upon the judge to weed through it, and he knows what's relevant, what's irrelevant, what's prejudicial, what's not. But with a jury trial, well, you still want to preserve the record. So you ask the court, can I make a proffer? And sometimes, some judges do not, as I said, it goes back to knowing your audience, knowing that judge, what their likes and dislikes, what their practices are. Some judges do not like to rule on matters of law in a vacuum. They like to get the full breadth of it to make a ruling. But you can make that proffer before trial, or you can make it when the issue comes up. But that's going to be up to the judge's discretion whether he wants to hear it and he's comfortable in ruling on that motion in limine prior to trial, or whether he has waited to rule on it during the course of the trial. So when you make that proffer, then you do preserve that issue for the record, because there's sometimes matters come up and you object, sustain, object, overrule whatever the judge's ruling is, and you just make a note. Don't forget, if you feel like you need to make a proffer, to make that proffer. Otherwise, the record, the transcript is going to be void, or that crucial matter to you is going to be absent. So that's how you would preserve that for purposes of the record, one way of preserving it for the record. The other things that the parties have spoke to concerning the motions in limine is something that goes hand in hand with the motions in limine is a motion for complete recordation, a motion to the witnesses not be in the courtroom while other witnesses are testifying. All that goes hand in hand with the motions in limine, and getting a complete understanding of what the court's ruling is, as Judge Schroeder stated, is clear because you want to avoid some type of sanction on either yourself, your client, or your case, your entire case, by your witnesses not being clear as to what their ruling is and knowing what they can and what they cannot testify to.
Thank you, Judge. So I've seen a couple ways to do motions in limine. Sometimes I'll see an omnibus motion in limine. It'll just have one motion, but then a bunch of like sub-motions. Other times, separate motions in limine. For the lawyers, how do you typically do it? And for the judges, if you have a preference, what do you prefer?
We'll do it however you file it. You file a motion, and if it's properly supported, we'll decide it. My personal preference is I'd rather have it in one document, because I've got to go through the docket if it's separate documents, and we're on an electronic docket, but I've got to make sure I have all the right pages that go with it and the responses. So if it's all in one motion, you have separate grounds, just delineate all the grounds, and then the response is going to do the same thing, and it's just as a matter of ease, it's a lot easier for me. But however you file it, we'll respond.
I'm inclined to accommodate the attorneys however you want to file it, but I keep on reiterating this: know the judge, because some judges have preferences on issues such as that.
I think from at least some of the strategic reasons I've seen us and I feel like others file omnibus motions in limine is to, for lack of a better way of saying it, obfuscate like the strongest one. To if they absolutely feel like they really want to win on a certain one, but they want to include it like buried in the weeds and bring a lot of the evidentiary issues in front, so then an adverse ruling on perhaps their strongest grounds doesn't forecast a difference in their trial strategy. I've seen, and I don't know if this is necessarily true, but this is something that I've heard others say, is that, if there are evidentiary rulings that are perhaps less strong that you feel like would give the judge an opportunity to make a ruling in favor of your adverse party, but then you're able to present your strongest evidentiary issue in that, and it would allow the judge to make the ruling in your favor on that issue, which is the issue you really want. Then you have strategically perhaps placed it in front of the judge in a way that would allow him to for her to see the strength of that particular motion.
One thing that I try to avoid when I'm filing motions in limine is addressing too many issues, whether that's going to be in separate motions or in one motion. So what I don't like, at least about the idea of an omnibus motion, is if that encourages filing a motion that says, number one, I want to exclude everything that's irrelevant. Number two, I want to exclude everything that's prejudicial. Number three, I want to exclude everything that's speculative. Those are just, you're just saying there, Judge, I'd like you to enforce the rules of evidence at this trial. Well, that's on you to object during trial, and I don't think the judges will disagree with that, but that if all you're doing is filing a motion and you're saying, see Rule 403, that you're really not doing the court any favors. The court is well aware that there are rules of evidence and is going to rely on you to highlight what testimony or argument you actually think should not be admitted and why.
So Judge Burke brought up what I think is a really important point, which is know your judge and what your judge likes and doesn't like, because you want to give the judge what the judge likes. But sometimes that's not so easy to find out. For example, in state court, I might have a case in Buncombe County or some faraway place where I hardly ever get to. And suppose you've called all the people you know to find out about Judge so-and-so and you haven't been able to learn anything. For Judge Schroeder and Judge Burke, is there anything improper about calling the case manager in federal court or the trial court administrator in state court and just asking them, Judge Burke is scheduled to be my trial judge. How does he prefer motions in limine, or how does he like to do that? Any improper ex parte contact there? How should lawyers approach that?
I don't think there's anything improper in contacting our case managers. Don't contact chambers, because I instruct my clerks not to talk to the lawyers, but contact the case manager and ask about procedural matters like that. There's no problem with that. We do have on the Middle District website a new page that has the preferences of judges. I can tell you that some are more active in putting their preferences on there, and some judges have very extensive lists of things that he or she likes. I've not been a big fan of that. I like to think if you go to court that you have some uniformity in what's going on, because it gets harder and harder as you practice law to do a lot of research on things like that. We have the federal rules and local rules, and hopefully they'll be applied. So hopefully our local rules answer most of your questions. But I don't mind calling the case manager, asking whatever questions you want, because your goal is to make it easy for you all and for the court to decide whatever the problem is between the parties. So one thing I might add is frequently lawyers don't talk to their adversaries. And the longer you practice, the more you realize what a benefit that is. And I know it's gotten harder to practice law, I think, in some ways over the last 20 or 30 years, but a lot of times these things get worked out. And frequently in court, when there are motions in limine, I'll tell the lawyers to put their heads together and tell me what's really at issue here. And they'll work out the issues in many of the cases. I don't know if it's horse trading or what's going on, but it gets worked out. Maybe they're fearful of something coming in, but the other party says, I'm really not going to offer that. And then they can represent to the court it's not going to happen. So that saves your client a lot of money, because time is money in this business, and it also saves the court extra time dealing with motions.
What's a delight for a judge is if you see a matter that's for trial, that judge can show up that morning, call for a jury, and you start that trial. It can kind of wear on the court sometimes when you have to go through so many pretrial matters, and you can spend all morning on the pretrial matters, and then you bring that jury in at 2 o'clock. And I like to preferably bring juries in the morning, because they get restless also. So just bear that in mind as a practical point. I don't see anything wrong with calling the trial court administrator, but another resource, you could call the courtroom clerk in state court. They work with those judges day in and day out. They're definitely going to know what the judges' likes are, because they're trying to appease the court also in how they perform their duties as a courtroom clerk. So that is another way of finding out information about a judge. And you know, you don't want anyone to feel like this judge called about you. You don't want to get on the wrong side of the judge, but I don't think it's going to go to that extreme that they would even share that with the judge. You're just trying to find out what the judge's likes, dislikes are, because you want to have a smooth operation in trial. Another thing is just when you show up in court that day, you can just ask the judge directly, Judge, do you have a preference as to this, that, or the other? I just think it always works in your advantage to know these things, because I imagine some of you may have seen that, and we would hope that it doesn't, and sometimes judges, their temperament can get beside itself when they're annoyed, and you want to keep the judge's temperament calm. It works to your benefit when you do so.
All right, thank
One-
you.
I'm sorry,
no,
sorry.
no, I was just gonna add one thing, just it came to mind when we're focusing on knowing your judge. One of the tools that I have found useful, having gone to law school outside of North Carolina, is the School of Government Superior Court bench book. I think when I found that, I was like, well, if I don't know the judge personally, and I don't know very many at all personally, but if I could at least see the window that they are given, and one of the tools, obviously it's not binding authority, but you know, it's at least a way that you can see how they view certain issues, or perhaps one view of the issues. I have found it particularly helpful on 9J issues in medical malpractice, because I think depending on what judge you get and what their level of experience is with medical malpractice cases, you would at least be able to reference back to, well, let me tell you what the bench book says. And I think that helps you establish at least a little bit more credibility outside of obviously the rules of civil procedure and the case law. So it's another tool.
If I may,
Yes, sir.
practically speaking, I think participating in any auxiliary group that brings you in contact with judges is to your advantage also. You may not approach a judge asking them about a legal matter. You could be in a road race with a judge, and you just never know where your conversation may lead you as to some type of practical skill that could assist you in appearing before that judge or any judge for that matter. So a lot of times we're at work and we may not want to go to a reception after work where judges are going to be, but it does not help you it does not hurt you as a practitioner if you do have the time to participate in the various auxiliary groups which will bring you in contact with judges.
Yeah, great point. Any questions on motions in limine from anybody?
Quick one now, this is bleeding into the afternoon and I'm kind of breaking the rules here, but I kind of want to ask the judges this. As you stated earlier, there's no time frame anywhere written on when you can file a motion in limine. So like in federal court, if I go to file a motion for summary judgment, I'm limited to 25 pages. However, a motion for summary judgment can only be decided on admissible evidence, and we're going to have a complicated issue. What I just did last time was file a motion in limine before I filed the motion for summary judgment, asking to, I learned through discovery basically what the other side was going to say, asking to have a ruling of it excluded, not only from trial, but also from any potential ruling on motion for summary judgment. And I'm just curious in your all's thoughts on that.
Typically, I would get that in the motion for summary judgment. I'm not saying it has to be that way, but normally I would get a motion for summary judgment and a motion to not consider certain evidence, usually under Daubert or something like that. And there is a page limitation in the Middle District. We actually were trying to come into the 21st century, so we went from page limitations to word limitations. And somebody said, yeah, 9,000 words. Well, after we voted on that as judges, somebody counted, and that's something like 40 pages.
So I have to interject. I'm embarrassed by that because I'm on the Middle District Local Rules Committee, and that's an illustration of why we all went to law school. We weren't very good at math.
Right.
We were trying to convert word count to pages, and we just messed up the formula.
Anyway, so it's now 6,250
Why are these briefs so long?
as of September the 9th. It's going to be 6,000 or something, so it's going back closer to 20 pages. You get another 2 or 3 pages out of the deal, but You could do that. I mean, the earlier in the process, there's a motion to exclude something. I mean, typically, I think a motion in limine, I would think of it as excluding evidence from consideration by the decision maker, and normally I think in terms of trial. And so if it's on a legal issue, I would consider it as subject to an argument that I shouldn't consider it on some legal grounds and then enter summary judgment. That's the relief you really want in summary judgment. But I hadn't thought about that kind of two-pronged approach.
I think that's relevant to federal court. I don't think that that's an issue that we deal with in state court. Local rules, be familiar with the local rules. That's been mentioned. In Forsyth County, all the dispositive motions have to be filed and heard prior to trial. But still, a lot of lawyers will file a motion for summary judgment to be heard the day of trial. And it's going to be at the discretion of that judge. Some judges will hear them, other judges will not. It's not in compliance with the local rules. But if it's a matter that it's an issue that may end the case, you never know. A judge may go ahead and hear it, depending on what the nature of the case is and what he's found out. But generally, those dispositive motions have to be heard and resolved prior to trial.
Any more questions on motions in limine? If not, why don't we talk about motions to exclude testimony, and in particular, excluding expert testimony. We all probably know the Supreme Court decided State versus McGrady last year, so North Carolina State Court, we're now officially a Daubert state, and the federal courts have been Daubert for a long time. Kevin, have you noticed any changes in your practice in motions to exclude expert testimony?
I would say that they're less successful. That experts are, I think if you're making general observations and extrapolating like big theme takeaways, I think experts are now given, so long as they're qualified under, I think it's Rule 704 and then 702, they're going to be given more latitude to testify about ultimate issues, legal issues, so long as that opinion is based upon reliable principles and methods that they've used to review the case or formulate that opinion, so long as it's based upon sufficient facts and data. These are really the three prongs of Rule 702, and so long as the principles and methods employed in that case are reliable. And so I think those would be the bases upon which you would challenge or try and exclude portions of an expert's testimony. But so long as your adverse party shows to a sufficient level to the judge, those three things, I feel like experts now are given more latitude to offer an opinion about ultimate legal conclusions that would impact the case.
So Judge Burke, sticking with state court, how do you handle motions to exclude expert testimony, and has anything changed much since State versus McGrady?
Being so recent, I don't really think so. But it's no different than what counsel has just stated. If it's a science that is relied upon, if that expert has information that he can bring to the fact finder beyond what the fact finder's realm of knowledge is, then usually that expert is allowed to testify. It's going to have to be some type of witch doctory, basically, for that expert to not be allowed to testify, or it's irrelevant. But it just falls right along the rule.
So I'm going to call on Judge Schroeder for the federal perspective. I just noticed in most of my federal cases, I almost always see Daubert motions, and I wonder if they're more common in your judgment, and if judges get irritated with them. I've often thought, geez, there's like 5 or 6 Daubert motions in the case, and the judge has got to spend all this time on these issues. What's the federal perspective on that?
Well, I don't know about the federal perspective.
Well,
I can give my
the federal
perspective.
Judge Schroeder perspective.
We still get them. I don't get irritated when they're filed, but we get a lot of motions that are filed as a matter of course. And so that happens in the Daubert context, in my experience. It also happens more so in the 12b-6 Iqbal Twombly arena. It's almost as if people feel compelled to have to file this. My biggest observation on Daubert-related challenges is most of the experts appear to be qualified. They are by training and experience. The real question is, what did you ask them to do, and how did they go about doing it? And the two-pronged goal of Daubert is reliable and valid. So reliability and validity. So the question is the expert qualified? Generally speaking, they almost all are. But I have excluded experts in the past, either in whole or in part, not so much based on their training and experience and education, all that. And they may have qualified in other cases. But what they did in the other case, they did differently. And just because they've been qualified before, even in a related matter, doesn't mean they're going to show up and testify if they're challenged, unless they fit the facts of the case. And one of the requirements under the Supreme Court precedent is that you have a good fit between the expert and the facts. So you can't just have an expert, give that expert a file, and then expect them to do all the work. You have to make sure that that expert's doing the right kind of work and is tying up all the ends so it connects the dots, so it's an appropriate thing. I had an expert in one case who had testified in other cases about a certain issue, and he was clearly qualified. And in the other cases, the facts were a little different. And then they brought the case to me, and my facts were different enough that what the expert typically did, I found was not sufficient, and I excluded the expert. So that's where I think you need to pay most attention in the expert arena.
Yeah, that's where I've had more success in excluding experts like Judge Schroeder. I find they're usually qualified, but it's what they're trying to do that may be objectionable. Oftentimes it's something that's not beyond the scope of common jurors' knowledge, and there are cases that say, oh, that's a no-no. Or there are a lot of cases that say you can't use an expert to usurp the role of the judge or the jury. And so oftentimes it won't be so much the qualifications, but what a lawyer is trying to get an expert to do. Kelly, what's your perspective in federal court?
And I would say that the time to start thinking about the Daubert motions that you might make, whether you're going to make five or six of them or maybe none, is way back in discovery. So the time to find out or to attack the experts, I mean, it may be the expert's qualifications, but you may just get a CV and you might see this person's been qualified to testify in 10 other cases. But the time to really dig in and make yourself an expert on what the expert has been asked to do and what they have done with the information they've been provided. And so thinking about the standard for admitting or excluding expert testimony, that needs to inform your strategy when you go to take the expert's deposition, so that you can close off or you can elicit things that will show that the expert's methodology is ridiculous, that the expert made it up on the spot. You can elicit information to show that the expert is really just relying on everything that counsel told them, and they didn't actually get any information and review it. They got biased opinions from counsel, and that's the basis of the opinion. So don't wait until you get close to trial to start thinking about whether the expert's opinions really ought to be admitted at trial.
Questions on motions to exclude expert testimony? If not, why don't we move to post-trial motions? Let's suppose that you've tried the case and you've lost. What sorts of things, motions, should you be thinking about, Kelly and Kevin?
Well, in federal court, they have different names, at least when they do in state court. But so in federal court, you may have gotten an adverse jury verdict, and you think, all right, well, there was really, at least in your view, not a sufficient evidentiary basis. And so I think this is Rule 50, Federal Rule 50 on motions for judgment as a matter of law, that you can say legally the evidence was insufficient to support that jury verdict. But again, the time to think about that motion is actually before the verdict has been entered against your client, because if you are going to ask the court, which you can do after the verdict, to enter judgment as a matter of law in your favor, you want to have done that before the verdict as well. So if I'm the defense counsel, at the close of the plaintiff's evidence, I'm going to be prepared with my argument on why the evidence that the plaintiff has offered is not sufficient. I'm going to renew that at the close of all evidence, and then if the verdict goes against us, then I'm going to renew that motion within 28 days of the judgment being entered. I'm going to file something to renew that motion. At that time, and also even independent of that, I'm going to be asking for a new trial. There are all kinds of reasons that you might be able to ask for a new trial. It's a high standard to meet, but I'm hopeful that the judges might share some of that with us, because at least in practice, I don't think it's something, you don't see it happen every day. You're not going to get a new trial every time you lose, unfortunately, but sometimes there's something that comes up. It might be a trial error that was so gravely prejudicial that a new trial is warranted. It might be that the evidence at trial is, while legally sufficient, so weak that the court decides that it's really, the verdict was really against the weight of the evidence. Or it might be that there's some kind of, maybe there's some kind of misconduct. You find out immediately after the trial that the courtroom security officer bribed the jurors, and you might get to move for a new trial on that basis.
You're not entitled to a perfect trial. Well, that's the goal of everybody. You're entitled to a fair trial. We strive to conduct a perfect trial, and Judge Burke may very well be doing that. I'm not quite there yet, but you're entitled to a fair trial. So that mistakes may be made. Things happen fast in the trial, and judges do the best they can to rule. So, so far I've not had to retry a case based on some improper conduct or some other reason to retry a case. A lot of effort goes into the front end to avoid that. You do, I think it's still the law, that you have to make your motion at the end of the plaintiff's evidence if you're a defendant, if you intend to move for judgment as a matter of law and new trial at the end of the case. So, in other words, it's like constitutional issues. You have to raise them and preserve them at every appropriate point during the trial, or else you waive them. If it's your first trial and you've never tried a case before, and if you're a defense lawyer, which many of you, most of you are, then at the end of the plaintiff's evidence, the judge, with the jury sitting there, is not going to say, well, Mr. Defense Lawyer, do you have any motions to move for judgment notwithstanding, or judgment as a matter of law, or at this point? That you don't ask that in front of the jury. But the judge may ask the parties whether they wish to be heard. And if you say no, the judge might keep going with the trial, and you've now just waived your argument. So just know that you have to say yes, and the judge will send the jury out, and then hear. Now, most judges will send the jury out anyway, but just be attuned to that. If it's your very first trial, you've got to know where the pressure points are in the trial to preserve your client's rights.
Two things that come to mind in this arena. If you file a motion for a new trial, it tolls the time for appealing the case, and you must file it within 10 days, if I'm not mistaken. So that's something that you have to act upon immediately, that type of post-trial motion. And don't get it confused with a Rule 60, and you don't file that Rule 59. It's been cases where the person filed that motion after being denied a motion for summary judgment. Now, it's interesting that your motion in limine can tie in to your motion for a new trial. At this time, the judge has heard the whole case. You just don't know what that judge has been thinking about during the course of the trial. He may have ruled against you in that motion in limine, But then after he's heard all the evidence, he said, maybe I shouldn't have let that in. Maybe that was prejudicial. So just bear in mind that you may get another bite at that apple if your motion in limine has been denied as far as some evidence that may be prejudicial.
Just talking about some of the things that you may consider when moving for a judgment notwithstanding the verdict is the possibility that the verdict that the jury returned awards damages on two alternate theories of recovery that independently cannot exist together. Like, for instance, if they had brought a state and federal constitutional claim and the jury maybe returned a verdict in their favor on that, but then they also had maybe a state statutory employment discrimination claim. So I think these are some of the strategic reasons why the way that evidence comes in at trial and then the verdict that's returned and to be, this perhaps belies the importance of your verdict forms, can give rise to new issues after the verdict where the judgment notwithstanding the verdict has its independent significance because of the way that the case was tried and the verdict was returned. And the reason that, one of the reasons that this is important is I think it's Rule 10 of the North Carolina appellate rules. I think it states in part like you have to make a timely request, objection, or motion to preserve an issue. So this would be your chance on perhaps this scenario where you have an alternative theory of recovery where they've gotten both. So,
Marte, I know we're about out of time. Any questions on anything before we adjourn? All right, thank you all very much.